Do we stand on the brink of chaos in the law? On May 15, 2025, the U.S. Supreme Court heard Trump v. CASA, a case whose surface issue sounds technical. Should lower courts have the authority to block federal policies nationwide, but which carries profound consequences for how Americans experience constitutional rights? At the heart of the dispute is President Trump's January executive order, which seeks to deny birthright citizenship to children born in the U.S. to undocumented immigrants and certain non-citizens. Lower courts quickly froze the policy through nationwide injunctions. The administration appealed, arguing that a single judge should not have the power to derail a national policy for the entire country. Solicitor General D. John Sauer, representing the administration, painted a familiar picture. The federal government is constantly under siege from a judiciary too eager to issue sweeping rulings. He warned of legal chaos when one judge halts a policy for everyone, especially if other judges might later disagree. His solution? Limit rulings to the specific plaintiffs in each case. Let the rest file their own lawsuits. To many observers, this might seem reasonable. Let courts be precise, not presumptuous. Let the judicial system do its work case by case. Isn't that how it's supposed to function? But justices like Elena Kagan and Ketanji Brown Jackson weren't convinced, and rightly so. Jackson likened the administration's proposal to a catch-me-if-you-can game, where anyone affected by an unconstitutional policy must chase the government through the courts, jurisdiction by jurisdiction, just to assert rights that should be protected from the outset. This isn't just about whose burden is heavier, the people's or the government's. It's about the nature of the burden itself. The administration wants to prevent a single court from issuing broad relief, but that doesn't make the government's job easier. It makes everyone's job harder. If a nationwide injunction is denied, then every affected person, potentially hundreds of thousands, must file separate lawsuits. Not only does this clog the courts, but it creates a fractured legal environment where one federal policy exists in some states but not others. The law becomes a geography lottery. A child born in Texas is not a citizen. A child born in Illinois is. Now imagine what this means for federal agencies tasked with enforcement. Instead of adapting to one clear rule, they must navigate a maze of conflicting rulings, different by district and constantly changing. It's no longer just about the government responding once. It's about responding again and again in every corner of the country. That's not a burden. That's a collapse of procedural coherence. Contrast that with the alternative, a nationwide injunction. Yes, it's disruptive. Yes, it stops the policy in its tracks. But it does so in a way that is structured, uniform, and reviewable. It forces a clear confrontation at the appellate and Supreme Court levels. And most importantly, it avoids hundreds of thousands of people being thrust into litigation just to prove they deserve what the Constitution already guarantees. This isn't us versus them. It's structured versus unstructured governance. Both sides talk about judicial burden, but they miss the deeper distinction. This isn't a simple tug of war over institutional power. It's a choice between a finite, managed burden, like centralized court action, and an infinite, unpredictable burden, such as hyper-fragmented litigation and enforcement. In a functioning system, some burdens are not just acceptable, they're necessary. That's what courts are for, to stop a law when it's unconstitutional before it spreads harm. To do so cleanly, to make policy contestable through law, not logistical survival. Limiting courts to plaintiff-specific relief in a case like this doesn't preserve order, it breaks it. The executive gets to launch a nationwide policy, but no single court gets to stop it nationwide. Instead, families are told sue if you want relief, and even if you win, the relief is just for you. That's not balance, that's asymmetry dressed as restraint. The real question in Trump v. CASA is not whether courts have too much power, it's whether they'll be allowed to use the power they already have, clearly, cleanly, and in service of the Constitution, or whether they'll be forced to stand aside while a storm of litigation breaks out beneath them. A nationwide injunction is not a judicial overreach. It is the only tool the system has to prevent national fragmentation. It's not about stopping the government, it's about stopping chaos. When the Supreme Court rules, it should remember this. Burden is not just about weight, it's about shape. And structured burdens, even heavy ones, are far easier to bear than the collapse that follows from pretending they aren't needed at all.